Mike?
He's
Got
got
your
his.
mic on?
This is Mike.
Okay. Okay, he's
Okay.
texting, so he's there. Rich Millard, absent. Jim Nelson here. Millie Wentz.
Here.
Okay, as everyone had a chance to review the minutes from our last meeting on August 28th, do you have any changes, or do we have a motion to accept the minutes?
I have one change.
Okay,
Agenda item number 7, there's a $50,000 cost figure mentioned there, and it should be $500,000.
Oops.
okay.
Yep. Thanks for catching that.
You're welcome.
Any other changes?
Motion to approve is corrected.
Second.
Go ahead and make roll call, Jim.
Lauren Flick,
Yes.
Chris Jenkins,
Yes.
Lester Lamone,
Yes.
Mike Badone,
Yes.
yes. Rich Millard, oops, absent. Jim Nelson, yes. Millie Wentz,
Yes.
Motion carries. And the first item on our agenda today, we have the privilege of having our city administrator, Ryan Stevens, join us today and give us an update on what's happening over on the New Method Laundry property.
Thank you, Mr. Chair. As everybody probably has seen as driving down Main Street, the majority of the facade has been removed. We do expect that most of the building will be removed by the end of this week to early to mid next week. So we've had some issues now on the west side property wall. I believe we've worked those out with the engineer. There's going to be a column that will remain in place on the New Method side. Part of that building was actually tied into the New Method building. So one of the support columns will stay, and we'll stucco around that to preserve that part of it, so that no additional engineering work has to be done on the west building. But continue to move forward. We have taken the old sandstone blocks that were on the upper east side of the building. Those have been taken up to the Public Works facility, and we are going to be storing those up there for hopefully reuse on a future project. Happy to take any questions.
Do you have any questions for Ryan? Let's see here, Ryan. I think that one of the things that we talked about prior to the city council meeting was what the city wants to do as far as facilitating something on that lot in the future that would be that would fit into the historic feel of downtown.
Yeah, I think this commission was a co-signer or accepting agency with the agreement that we signed with the EPA as well as SHPO, State Historic Preservation Office, that that lot would not remain vacant forever. We do have additional work that needs to be done from a cleanup side. So after the building's removed, we're working with the EPA to have somebody come in probably mid to late October to do some additional assessment there. But long term, well, short to midterm, more than likely will be a parking lot. Long term, though, probably that 5 to 10 year range, maybe 10 to 15 years. We would like to replace that with a building at some point. Rick Harmon, our economic development manager, and I have been kicking around different ideas on what could be done there. Potential for retail incubators or a maker space of some kind on the main level, and potential for some attainable housing up above. So there's lots of ideas, but we have to get into the details of that, try to find funding for it, different things like that. But there's certainly some ideas that we're working on to make sure that we don't have a gap in the smile of Main Street for too long.
I know we talked about this before, but the testing for the contaminants is something that you really have no idea how long that will take? Is that essentially one of the driving factors to not moving forward with anything sooner?
I think the testing won't take terribly long. It will be once we get those test results and understanding what the level of contamination is and what the fix is going to be for the contamination. Depending on what those fixes are, whether it's removing more soil or if it's through natural attenuation, depending on what that fix is, that's going to drive how long we have to monitor the site.
Thank you, Ryan. Any other questions? Okay, Ryan, thank you
All right.
for joining us today.
Thank you.
Item number 5, commission orientation. I understand is Austin Flanagan with the city attorney has joined us.
Online.
Okay?
Yeah, hi there. Can you hear me?
Yes.
Great. So I'm not able to turn on my video. It looks like the video has been turned off for the meeting, so might just be hearing my voice for this one. I do have a PowerPoint though. Would I be able to, if I share that, will you guys be able to see that?
I see something now. Yes,
Okay.
there we go. Yes.
Okay, excellent. So let's just see here. All right. So are you able to see this Historic Preservation Commission orientation slide?
Yes.
All righty, excellent. Okay, well, happy to be joining you guys today. So my name is Austin. I work with Corey and Catherine as a part of your city attorney's office. I'm going to be running through a pretty brief, here we go, a pretty brief presentation today to go over some common considerations for board members. So we're going to start with the board's scope of authority as laid out in the municipal code. Then we'll go through some general considerations, and then we'll finish up with sort of a grab bag of some of the most common legal issues that present itself to commissions. All right, so within the municipal code, in 1230-60 of the municipal code, the Historic Preservation Commission's powers and duties are laid out. There are quite a few. I have half on this slide and half on the next. And you'll see that there's some quasi-judicial and some legislative authority, and we'll talk about that a bit more later. But what I mean generally by that is quasi-judicial stuff is the kind of stuff where the commission is acting on a particular application. Whereas a legislative action would be a broad display of authority, so like passing a design guidelines. So again, I won't go through all of these scope of authority today, but it's important to keep them in mind because these are really the main prerogatives and missions of the commission, and this is sort of the authority to which the commission should act within. So here's the second list of items for the commission's authority. Okay, so jumping right into some general considerations. So first, the Historic Preservation Commission is a body, not individual. So it has to act as a body. As you all know, that means acting by motion, second, and majority vote. So with that, no single member has the authority to act on behalf of the city. It has to be in that delineated process. And there's no authority for the commission to spend funds. That authority rests exclusively with the city administrator and the city council. Likewise, there's no authority to direct or supervise city staff, and any issues with city staff should be addressed with the supervisor of that applicable employee. Any legal advice provided to the commission from my office or other attorneys representing the city is confidential, so that could come in the form of an email to the commission or a memo or however else it might come. That information should remain confidential as attorney-client privilege. And then no authority to bind the city legally. So the Historic Preservation Commission can't, on its own fruition, enter into contracts. Again, that authority rests with the city council. And then lastly, it's not a separate legal entity apart from the city. The commission is an entity within the city. Okay. So there's really three buckets when we talk about actions of the commission, as I alluded to just a couple minutes ago. And so the first bucket is those quasi-judicial items. And so that's a discrete action related to a specific application type. So think approving a designation, an alteration certificate, or a certificate of exemption. And it's important to know when you're acting in a quasi-judicial manner because due process is triggered for those quasi-judicial actions. And due process is that guarantee we have from the state and the federal constitution that adjudicators should be fairly given a chance. So they should be given proper notice. It should be that a decision is made within a hearing setting and that the decision maker is neutral coming into that action. So in other words, the example I often give for this one is if you were a part of a criminal proceeding and as you were walking into court, you saw that opposing counsel was talking it up with the judge. And you heard the judge say something to the fact of, yeah, there's just no way the other side stands a chance. Well, that wouldn't give you much relief in knowing that the adjudication that was going to come before you was going to be fair, that due process rights were going to be guaranteed. And so that's the kind of thing we want to avoid. We really want to make the decisions related to those quasi-judicial matters based on the record that is a part of the hearing of that decision and not beforehand. So again, the primary duty there is to apply the criteria in the code to the evidence presented at the public hearing, to act fair and impartial, not engage in ex parte communications. That's like the example I just gave you, talking to perhaps the applicant or other commissioners about the merits of the application before the hearing, not being biased in your rendering of a decision. And those decisions are subject to judicial review. In other words, the record of your decision, if it is challenged, will eventually end up in district court, where a judge will get to decide whether the commission acted fairly and actually upheld due process and applied the criteria in the code to the application. Okay, so that's bucket one, that's the quasi-judicial stuff. The second bucket is legislative actions. And as we go down this line, there's less legal risk with each of them. So quasi-judicial, highest sort of legal considerations and constraints. Legislative, a little bit less. So a legislative action would be generally applicable. It applies broadly all throughout the city. So like creating historic preservation regulations or design guidelines, those are legislative actions. Those actions apply broadly, not to a specific application type. And really the only thing, or the main thing I should say, that you want to avoid in those proceedings is acting fraudulently. So not passing some legislation because you know it's going to benefit you personally. Just want to avoid that kind of stuff. And then the third bucket is sort of this administrative type bucket. And that's to say that even when you're in your day-to-day life, you're still a representative of the city. So it's sort of a hat that is really difficult to take off. But it's a good one to keep in mind. And again, the real rule there, or the real consideration there is, again, no fraud. So don't act in a way where you're trying to, for example, bind the city to an action because of your role on the commission. Okay, so and again, I should have said this from the beginning. My plan was to just get through these about 10 or so slides, and then I'll leave plenty of time for questions if there are any. Okay, so next up, we're going to start going into our grab bag of common legal issues that the commission should be aware of. So the first one is open records, and this is regulated by the Colorado Open Records Act, which is commonly referred to as CORA. So under CORA, public records must be open to public inspection. And CORA has a really broad definition of records, and it seems that case law keeps broadening and broadening what is considered a public record. And it's really all writings made or maintained or kept by the commission or its individuals in an official capacity. So that means that public records include correspondence of those officials, commission officials, except to the extent that it's work products. And so that's really broad. And recently, courts have found that even text messages, a group message between multiple commission members is subject to QORA. You have to release all of those texts if that is occurring. Obviously, emails, any sort of information that doesn't constitute work product would be released under QORA. So it's a really broad ability for folks to get records from the commission or other public entities. And so the advice I give my clients is to say, know that whatever you're writing in a capacity that might affect the commission or the commission's actions could be subject to public disclosure. So when you're typing something, an email or a text message related to your role on the commission or other folks on the commission or staff or what have you, just keep in mind that it could be subject to QORA. It could become a public document. Okay, moving on to the open meetings law. This is commonly referred to as the Sunshine Law. And really what the open meetings law is primarily concerned about is notice and public availability of meetings. So the general requirement here is that anytime 3 or more commissioners are together under the open meetings law, that's considered a meeting of the commission, and it must be noticed at least 24 hours in advance. So we run into this a lot. So for instance, say, 3 or more members of the commission want to go to a conference. Is that a meeting? Yes, under the open meetings law it is. The solution there is actually quite simple. All you have to do is let staff know that 3 or more members are going to be attending X or Y event. Could you please notice it? And they'll just put up a quick notice on the website, and we will be good to go. Another, I guess, important point here is that string emails have been considered a meeting. So if you have an email with more than 3 commissioners on it, and the commissioners are the one responding to that email, that's considered a meeting. And so it has to be publicly noticed and open to the public. Obviously, that's sort of impossible for email. So the solution is that whenever a commissioner is wanting to email about an official action, email staff that email and say, hey, can you please get this out to the rest of the commission? And the one exception to the open meetings law is executive sessions. I understand the commission does this extremely rarely, so I don't think we have to spend much time here. But the important part is that it's an exception to the open meetings law, but it's really particular on the reasons to which you can go into an executive session. One example would be to have a conference with the city attorney for attorney-client communications. Okay. Moving on to conflicts of interest. So generally for conflicts of interest, what the commission should be aware about is not having any sort of financial or economic interest in any decision you're making, or a family member. So for instance, if your spouse is coming forward with a demolition application, that's probably going to arise to a conflict of interest. And at the very least, I would encourage commissioners to disclose that interest publicly. And then if you feel that it rises to a conflict of interest, in that case, you can just go ahead and recuse yourself and leave the room. And if you're not sure, that's okay. You can just disclose the interest and then allow the commission to make the decision by a majority vote of whether they find it raises to the level of a conflict of interest. And if you ever have those questions, feel free to reach out to my office. We're happy to talk you guys through that. Okay, moving on. So this is the last sort of nugget of legal information, and then I'll stop talking. It's really important to keep these considerations in mind, all of these different legal parameters in mind, acting within your scope of authority, because if you generally uphold the considerations I just discussed with you, then you're going to be protected, you're going to be immune from liability for your actions. In other words, if someone decides to sue the commission for not giving them a demolition permit, let's say, or just not getting the decision that they hoped for in some type of application, and they decide to sue the commission and the city over that. Well, you're going to be immune from liability personally, so long as you don't act willfully and wantonly, and you're acting within your scope of authority. So again, going back to one of those earlier examples, if you're applying the criteria based off what was in the public record to that application decision, then you're totally good. You don't have to worry about someone coming after you individually for any kind of liability that might arise from that situation. But we could be in trouble both from the city and then yourself individually if, that's not the case. If you're, encouraging commissioners before the meeting to vote against an application, to vote for it or what have you, then we could be in some trouble. So just be cautious of those kinds of considerations. Alrighty, that is all I had. Thank you for the time, and I'm happy to answer any questions. I can stop sharing, although I don't believe we can see each other regardless.
Thank you, Austin. We appreciate you joining us today. Any commission members have any questions?
I have one question, Austin. Under our powers and duties, the ordinance mentions to develop and assist the public in public education programs and to act as a resource for owners of historic buildings. Is that a fourth bucket, or does that fall under your administrative bucket?
I think that would fall under the administrative bucket. Really good question. And that's going to be a tricky one because you want to be careful in those situations to really limit it to broadly applicable issues. So if someone's coming forward to you and saying, hey, I really want to get my demolition permit approved, that's the kind of thing where you want to back away and say, hey, I'm going to be a decider on this. I've got to be an impartial judge on that application. So I can't help you with that. But if they had broad questions about like, hey, I really want to understand better what the Historic Preservation Commission does and how to get involved, then absolutely you can take part in that education. Hope that answers.
Okay, yes, thank you. One more question. The three or more requires a public notice. If three of us are a member of another organization, say the County Heritage Commission, and we attend a Heritage Commission meeting, does that need to be posted?
So technically under the law it does, and I know it's a total pain, but I would go ahead and let your clerk know that, and she can just post, or they can just post every single one of those meetings and just say, the following commissioners meet on these dates for this purpose.
Even though that even though that it is a county commission and the county posts it publicly?
Yeah, the issue there would be that because three of our commission meetings are together,
Okay.
it still would trigger the open meetings law requirement for us individually. So that's a tricky one.
Although the agenda for the Heritage Commission would spell out what was going to be discussed, and it would be posted publicly.
Yeah, I think that, candidly, I'm not too concerned about it because I couldn't see a type of challenge that would benefit from that. But just looking at the four squares of the law, it would say that this commission has three or more members who are serving in a different capacity at a different meeting, and this commission did not notice it. Therefore, it's a meeting under the open meetings law. Three or more commissioners from the Historic Preservation Commission are meeting, and we, the Historic Preservation Commission, are not noticing it. So is it technically an issue with the open meeting law? Yes. I think could be a fairly simple solution to just notice every single one of those meetings on our website too. Of three or more commission members serve on this board and they meet at these times.
Thank you.
You got it. Good question.
Any other questions? Amy?
Thanks, Chris. Thanks so much for that presentation, Austin. One quick question for you. I noticed a couple of spots in your presentation where it referenced elected officials. Given that the commissioners are appointed, I'm assuming that it still applies to them and that it's just language taken from another purpose?
It does. I should have changed all the appointed to elected. Thank you for that consideration. And I can get you a updated PowerPoint with that change.
Okay, no worries. Just wanted to make sure we were on the same page. Thanks.
Okay, good question.
Any other questions? Millie, you look like you're thinking very hard.
As long as I only think, then we're okay.
Austin, I think that covers it. We do appreciate you joining us. It did spell out a lot of the things that I think we probably breezed through when we first joined the commission and did not take into consideration. So certainly I am appreciative of you joining us today.
Thank you, sir. I appreciate the time. You guys have a great day.
Thank you. Okay, moving on. Agenda item number 6, development guidelines for the Historic Downtown Committee report. Lisa, do you have a summation? And Lester, do you want to add once you give us a summation? Lisa?
Yes, we just met prior to this meeting. We sort of we discussed chapters to highlight in our guidelines, design guidelines. I think we've gotten down to 2 phases. Phase 1, addressing guidelines for existing buildings, and then phase 2, addressing guidelines for any infill or new buildings within the defined historic district. There was a discussion on what we would define as the historic district, and going forward, looking at surveying other areas that are adjacent to the current one, the boundaries. And then we are having our next meeting in 2 weeks.
Lester, would you like to add to that?
That was a very good summation. I think that at this point, we're trying to put a framework around how we take off smaller chunks and develop those guidelines. So, but yeah, we'll just, if you're interested, stick with us every 2 weeks. We're making headway.
Any other questions or comments? Moving on to general announcements. Lisa?
So our annual report for our CLG is due on November 1st, so I'll be working on that this next month. The application for the CLG grant cycle is going to be out on October 1st. I believe that is due January, sometime in January. There's a potential for applying for that grant this cycle for another survey project. I'm looking into a couple different possibilities, and I can get you more information next meeting. As for webinars and training opportunities, the next CLG training webinar will be on the CLG grants on October 16th. And if you're interested in that, you can register for that via the CLG portal.
Thank you, Lisa. And I think we wanted to, if we could, get a link to a CLG surveyor information list, just so we know what we need to do, and at least get that in our hands, maybe where we can start thinking about what we can do as commission members to do that survey of downtown.
Yeah, I'll look for that and I'll send that out, or I'll have it definitely by our next meeting for the committee in 2 weeks.
Okay, anything else you'd like to add to that? Okay. Moving on, any general announcements by any of the commission members? Amy, do you have anything you'd like to add?
I just wanted to recognize Commissioner Millie Wentz for being a finalist in the Fremont Exceptional Women Awards for this year. Thanks so much for everything that you do for our community, including on the Historic Preservation Commission.
Thank you.
Yes, thank you, Millie. Okay, anything else? Public comments. Is there anyone who would like to make any announcements or public comments? One thing I just wanted to touch bases on, just to kind of plant this in everyone's brain to think about here as we move forward. Had a conversation with Stan Bullis over at Unbridled, who, as most of us know, has put a lot of time and effort and money into restoring a lot of the fantastic, beautiful historic structures in our community. But we had a conversation briefly about the building out at St. Scholastica, and it's really, it has me a little concerned, mainly because it's in such a deteriorating shape, and the cost to renovate it to really a usable state is somewhere in the neighborhood of about $14 million, and yet it appraises at $7 million with the improvements. So it's certainly going to be a daunting task, and it's certainly one of the fantastic historic structures in our community. But I just wanted people to think about it, and as we move forward, if something comes up that we can do to assist any owner or future owner, or whatever we can do as a Historic Preservation Commission to make sure that structure remains in our community is something I would personally be appreciative of.
Mr. Chairman, if I can make a comment. I guess conflict of interest notification. Scholastica is my project, has been for the last 7 years or so. So ownership of the Cabrini building has changed a couple of different times, and maybe changing again. But what I'd like to say about that from a historic preservation perspective is we as a community, we as a society, won't save a building that has no use. So the number one thing that we need to do is to find a use for that building. When that building becomes useful, the building becomes relevant. And when the building becomes relevant, funds appear. So it is a worthy building of saving, not only for its historic contribution to the community, but it's just a substantially stout building. It's doing its best to not be because of weather and neglect, but again, I'll say this as a general statement for all historic architecture: without a use, they go away. So if you want to really help the Cabrini building, come forward with a use.
Very good input. Lester, thank you very much. Anyone else have any comments or thoughts on that item? Anything else, folks? If not, this meeting is adjourned. Thank you for joining us.